The topic's name is drafting of affidavits and counter affidavits, civil and criminal. So before we go to the counters, let's discuss what do we mean by affidavit. So this affidavit derives its name from a Latin word called affidare, which simply means he has sworn, he has pledged his faith. So whatever you say on an affidavit in common parlance in legal world, it means only one thing, that you are saying these things on oath. You are saying these things with all your faith and with all your authority. So why do we need affidavits? Why people want affidavit? Why authorities direct? A lot of people might be reading in the newspapers that someone in the authority has been asked to file an affidavit by Supreme Court or High Court for a certain fact. Why affidavit? Why not a written submission? Why not a written reply? Because by affidavit, certain degree of certainty comes in. Affidavit is neither a pleading nor a written submission. It's something more. It's a declaration on oath. You are saying something, you are asserting something, and that too on oath. Who is administering that oath? How is it happening? I will come to that part later. But in this beginning session, I will be directly coming to the importance of affidavits, like how do we make affidavits. So first of all, if we see the CPC, Civil Procedure Code, it provides for affidavit in Order 19. Therein, it talks about that affidavits can be given and affidavits would be handled by the courts. And if I may read Rule 1 of Order 19, it says any court may at any time, for sufficient reason, order that any particular fact or facts may be proved by affidavit, or that the affidavit of any witness may be read at hearing on such conditions as the court thinks fit reasonable, provided that where it appears to the court that either party bona fide desires the production of a witness for cross-examination, and that such witness can be produced, an order shall not be made authorizing the evidence of such witness to be given by affidavit. So this is about affidavits, that evidence is given by way of affidavits at times. And then the CRPC has different provisions for it, and IPC has some provisions. So affidavits are given. So first of all, why affidavits are taken that much seriously? Because it's legally enforceable. So if someone lies on an affidavit, then that person is liable. Parliament has made it an offence, and explicitly that offence could be seen in section 191 of IPC, and that offence has been given a new name with almost same colors and connotations in section 227 of BNS, that's Bharatiya Nyaya Sanhita. So it simply says that if you give a false affidavit, it's an offense and you are punishable up to 7 years. Though the offense has been classified as bailable and non-cognizable. So at prima facie level, it doesn't have a lot of force. Means police cannot arrest you without warrant, and it cannot be investigated into without the authorization of the court. But the offense is there and it carries a lot of punishment. So there is a deterrent. Like if court is asking an affidavit from you and you lie on the affidavit for anything, any document which has been authored by you, made by you on affidavit, or you have given an affidavit in support of that document or that paper, if that thing goes wrong, you can be held liable. And that's why affidavit. It gives certain degree of seriousness, certain degree of certainty, and certain degree of enforceability to a document, to a process, and to an instrument. That's why affidavit. So this is the reason affidavits are there. And before I go into the court aspect of it, uh, part of it, affidavits are enforceable through the penal law. And if some affidavit has found to be false, so there is penal law, IPC, BNS. Besides that, the contempt of court is also attracted, because at the end of the day, false impedes justice. False creates chaos in entire judicial setup. So anyone who is lying on oath, is creating chaos in the system, is hampering the course of justice. And anyone who hampers a course of justice is committing a contempt of court. So, besides the penal provisions which are there, you can you can also be held accountable in this contempt of court provisions. So, there is a lot of enforceability. The first enforceability is penal law, regular penal law. Besides that, if some affidavit has found to be false by a court, inside a court, during a proceeding, then criminal court proceedings are also there, and you can be held liable. You can be burdened with costs. You can be sent to prison. So a lot of things could happen to you. That's why affidavits are taken seriously. That's why people tend to ask for evidence whenever something has to be said with a certain degree of seriousness in any formal setup. So this was about the beginning of the affidavits, what we mean by an affidavit, and how the affidavit works in common parlance. So, so what does the affidavit constitute in a simple term? So if you come to this So if you come to this page 11 of the compilation, which I have shared with you, it will show two, three things very explicitly. We have tried to make a format of affidavit. This affidavit is visible to you so that the court's name is there, case number is there, names are there, description is there. Thereafter, the heading is there, affidavit. And then you read, I, let's example, X, son of Y, aged 25 years, occupation engineer decides. So you write all these things. Why do we write all these things? Because these things make your identity clear. When I tell my name, when I tell you my father's name, when I tell you my address, when I tell you my age, occupation, and residence, I make myself traceable. I cannot say something and go away. I am traceable. And thereafter it says, I solemnly affirm that my declaration is true, that is conceal nothing, and no part of it is false. So this is how it begins. That I give all my declarations and then I solemnly declare. And thereafter I say whatever I want to say. A simple example is given here, but it could be something else as well. But this is how it begins, and there is a reason why it begins like this. Because once I divulge all my details, I make myself traceable. And second aspect would be that affidavit in support of writ petitions. So if I'm filing a writ petition again, I will at page 13 you can see that I will be writing these things, that no part of this petition is wrong, and I will be saying that the documents given in this writ petitions are true, original, they are not forged, all those things, and that thing is signed by me. And then these affidavits at page 15 available in criminal cases. As far as criminal, if you see CPC has a scheme. CPC scheme says that every government has to be supported by affidavit. That's why in civil cases, usually with everything, affidavit goes. But as far as criminal cases are concerned, in criminal cases, there is a catch. So if you are a complainant, if you are saying that I am a victim, then things which you say are usually supported by affidavit to safeguard from frivolous petitions and frivolous affirmats and processes. But once you are an accused, you are protected by Constitution, which says that no person shall be compelled to be a witness against himself or herself. That's provided in Article 20, subclause 3. So you can't be compelled to be a witness against yourself. So when a criminal gives anything to the court, he is free to give affidavit. He is also free not to give affidavit. So if someone is filing a bail application, in common parlance, affidavit goes with it. But if someone takes a stand that I don't want to give an affidavit, then they can't be compelled to give an affidavit. They can give undertakings, but saying things on oath for an accused is something not known to criminal jurisprudence. So as far as complainants are concerned, as far as victims are concerned, they are supposed to give things on affidavit. I will show the judgments in the later part of this discussion. But as far as accused are concerned, they have this liberty to say things even without affidavits. So when the statement of accused happens in court under section 313 of CRPC, that statement is taken after prosecution's evidence and before the defense evidence in a criminal trial. And that statement begins with the declaration by the court that not on oath, because he is an accused, he can't be given oath, because if he is given oath, he is supposed to say things which are right. But an accused can't be compelled to be a witness against himself. So for this reason, accused has this exemption, and they are not forced to give these such type of documents. And then comes this counter. We have tried to give you an example of counter at page 17. At page 17 of this compilation, if you may see that we have given a counter affidavit on behalf of, we have tried to hide the identity of a gentleman. It's a real life counter which has been filed in a petition wherein one of the victim had approached the court for cancellation of bail of one of the accused. So there is a criminal case. One of the accused has been granted bail by High Court. The aggrieved party or victim or complainant approaches Supreme Court in the extraordinary jurisdiction of specially petition criminal and says that this shall not be happening. And then you have these petitions happening. So someone has approached the court saying, has filed a petition saying that the bail granted by High Court is wrong. It shall be cancelled. So the person who has been granted bail is given an opportunity by the High Court, by the Honorable Supreme Court, to put forth their story. And they are putting forth their story through a counter affidavit. So they are giving their reply in the format of counter affidavit. Court wants everything to be serious in this stuff, and no, they don't want extra words. That's why it's in the form of counter affidavit. So people write it with certain degree of seriousness, and they just don't put extra and unnecessary words, because everything you say in counter affidavit is on oath, and it makes you liable, as we discussed earlier. That's why counter affidavits are taken. And now at page 70, you will see all the details are there. Then his person's description is there, that what happened, that it's a case where some between husband and wife where the wife committed suicide, and then they are facing all these things. At page 19 are preliminary submissions. So what do we mean by preliminary submissions in a counter affidavit? So in a counter affidavit, preliminary submissions are a very important portion. Here we question what's happening actually. So let's take the example of the petition at hand, that the accused has been granted bail by the High Court, and the victim has approached the Supreme Court saying that this bail shall be dismissed. Now what to do? What options the court have? Court is taking the response of accused. Now the accused person first of all makes the preliminary submissions in his arguments. In preliminary submissions, you can object to the maintainability of the petition. By the maintainability of the petition, like multiple grounds could be taken. So, for example, exhaustion of remedies. So, for example, if someone comes to Supreme Court directly in a writ petition saying that municipal corporation shall be directed to clean the roads, the municipal corporation, when it's filing this counter affidavit through one of its official, can say that they have not written to us. They have not apprised us of the problem. They never gave a representation to us. So this writ is not maintainable. They have not exhausted their remedies. So if I have a problem with municipal corporation, the first reasonable thing is to do is to tell them that I have a problem. Is to tell them that there is garbage outside my house. Without telling the authorities, if I directly go to the Supreme Court and saying that my right to life is getting harmed and infringed by the acts of MCD and file a petition, then a response will be short. And in the response, the first objection is in preliminary submission is of maintainability, that they did not exhaust their remedies. And that's a very genuine objection to be taken. Other objections of maintainability could be of territoriality. Now, in the High Court of Delhi, if someone files a writ and the writ's issue and dispute and cause of action pertains to something happening in Tamil Nadu, then the responding party, then the respondent in their counter affidavit can say that this Honorable High Court doesn't have the territorial jurisdiction. And such type of submissions could be made. So preliminary submissions are to question the very basis of the petition which is under reply and which is under the dispute. So it's something which has to be taken seriously. You need to respond. You need to tell the court why this petition in itself is not maintainable. So that's an opportunity, a great opportunity to be utilized very nicely. If you tell the court in a very reasonable, precise, concrete manner that these are the reasons why this petition is not maintainable, then there are good chances that the petition would be dismissed at the threshold only. Then the second portion of it is parawise reply. So how does the parawise reply portion looks like? So in this compilation, the reply to grounds is at page 21. So there are grounds to this petition which have been responded with, and thereafter thereafter this parawise reply or reply to grounds is there. They are trying to respond to these grounds in a very specific manner. In ground A, you have written this, that's why it's wrong. In ground B, you have written that, that's why it's wrong. So basically, in SLP of Supreme Court, you only have question of law and grounds. So you can only respond to grounds. That's why they have responded to grounds in a very parawise manner, in a very clinical manner, that this is not made out, this is not there. So they have done the due diligence. And in the last page 25 is the prayer. And then they say that this special leave petition is devoid of merits, it may be dismissed. And in the end, it's verified. So this is a counter affidavit and Honorable Supreme Court. For the sake of clarity, I am clarifying again that in this case, an accused in a case where the between husband and wife, where wife had committed suicide, husband went inside the jail, then husband approached the High Court and was granted bail. One of the family members of the deceased wife approached the Supreme Court in SLP criminal saying that this bail shall be cancelled. And when this petition was filed in Honorable Supreme Court, the person who was granted bail was asked to file his response as counter affidavit. And what we read is his counter affidavit, wherein we saw basically two big portions of this counter affidavit. First portion is preliminary objection, wherein the gentleman is trying to say that why these proceedings are not made out against him. That's one thing. And the another thing is like this parawise reply or reply to grounds, because in SLP you only have questions of law and grounds. So at the end of the day, you are left with grounds only. So they have replied with grounds only. But on particularly on criminal side, the main thing is to keep it short. That's applicable on the civil side as well. You need to keep your counter affidavit short, precise, and particularly on criminal side, you don't need to reply it parawise. Like they have done so in the draft which I have shared, they have done so, but it was not required. They could have taken the gist of it, three, four points, and they could have responded to it in a very thorough manner, and that would have been sufficient. So the in criminal side particularly, the idea is to keep it short and simple. In civil side, you need to counter everything in a very substantive manner. Otherwise, at times it's deemed admission, as CPC says in. But as far as criminal side is concerned, saying less is helpful. That's applicable in the even during the cross examinations. But I will confine this to affidavits and counters only. So this was this part only. I wanted to show you some real life example of how Supreme Court sees these affidavits and counter affidavits. So Supreme Court, when the things are filed in Supreme Court, everything is governed by Supreme Court rules 2013, and they have a detailed order that's called Order 9, which governs the affidavits of Supreme Court. I have those rules with me. Order 9, it says that Supreme Court may ask affidavit from anyone during the hearing. And it says that at Rule 5 says that affidavit shall be confined to such facts as deponent is able of his own knowledge to prove, except on interlocutory applications on which a statesman on his behalf may be admitted, provided that the grounds thereof are strict. So these things are there. So that was how Supreme Court sees affidavits. So because in news we see regularly that Supreme Court has asked affidavit from this one or that one. This is how it is governed in law. So let's come to this judgment. It's a very famous judgment, in fact, Rajneesh versus Neha. Anyone who has practiced on matrimonial side would have heard about this judgment for sure, because this judgment tries to discuss something very difficult. So let's see at page 29, last three, four lines. I will read it. It's a very simple maintenance case between husband and wife. And the court takes the opportunity to settle their problem and also to frame certain guidelines so that every case doesn't land up in Supreme Court and people get remedies for which this whole law was made. So at page 29, I will read last three, four lines. The present criminal appeal arises out of an application for the interim maintenance filed in a petition under section 125 CRPC by respondent wife and minor son. So basically, this petition was filed by the wife and son. Respondent wife left the matrimonial house in January 2013, shortly after the birth of the son. On 2nd September 2013, wife filed an application for interim maintenance under Section 125 CRPC on behalf of herself and minor son. The family court, via a detailed order dated 24th August 2015, awarded interim maintenance of rupees 15,000 per month to the respondent number one wife, and this maintenance was awarded. So, a wife goes to court, asks for maintenance under 125 CRPC. She is awarded interim maintenance. So, maintenance petition. This petition is for the maintenance, permanent maintenance. But before the petition could be decided, unfortunately, in this country, to decide a petition, it takes 5 to 10 years. So a person cannot be asked to starve during the pendency of the petition. So they are granted interim maintenance. That's akin to interim reliefs, which usually we get in civil cases. So this wife has been granted an interim maintenance of rupees 10,000 for herself and 5,000 for the children. Point two would tell you that the husband approaches the High Court and High Court dismisses it. The husband doesn't stop there. He comes to Supreme Court and the matter is now before the Supreme Court. So Supreme Court sees the matter and it expresses its dismay over the situation. At page 32, at page 32, Supreme Court says at para 10 that the judgment is right and the court below is directed to decide. Now, in the same page, at page 32, there is part B. Therein, the court says that facts of the present case, which reveal that the application for interim maintenance of 25 has remained pending before the courts for 7 years, and now there are difficulties being faced by a destituted wife, because in this case the wife was not being maintained by the husband, and husband had an obligation towards wife to maintain her. He had sufficient means to maintain her. He was just not doing it. There was petition in the court, but by one way or another, the liability was being avoided by the husband. So court didn't take it very lightly, and the court decided to frame certain guidelines towards this whole thing. So if you see, after a very lengthy discussion at page 66, court frames certain guidelines for this maintenance and interim maintenance and its enforcement. At page 66, there is paragraph 95. It says, the order or decree of maintenance may be enforced like a decree of a civil code through the provisions which are available for enforcing a money decree, including civil detention, attachment of property, etc., as provided by various provisions of the civil procedure, more particularly section 51, 55, 58, 60, read with order 21. The striking of the defense of the respondent is an order which ought to be passed in the last resort if the courts find to be willful and particularly to be a dependent unemployed wife and minor children. Contempt proceedings for willful disobedience may be initiated before the appropriate court. So court is trying to tell that how these things will be done. At para 97, it says that these directions can be considered law as framed under Article 142 of Constitution. And as far as issue of overlapping jurisdiction is concerned, like there can be multiple maintenance petitions under CRPC 125, under Section 24 of Hindu Marriage Act, under uh, Domestic Violence Act 2012 petition. So different proceedings could be there. How to manage them? For that, guidelines are also there. So at the core of this whole judgment is page 68. Court says that, okay, how do we get to know someone has sufficient means, someone has filed how many cases? How do we manage it? Because court is trying to attain enforcement of these interim awards. How to do it? How to find that truth? They are trying to find the truth through affidavits because affidavits are enforceable. But people have a tendency to find means and ways to avoid liability even on affidavits. So at page 68, you will see the Supreme Court has went to the length of even drafting an affidavit. So there are two affidavits pro forma which are before us. The first pro forma at page 68 is of enclosure 1, which is affidavit of assets and liabilities for non-agrarian deponents. So, for example, there is a lawyer who is a husband or wife, or an engineer who is an husband and wife. So, if they have a matrimonial dispute and some maintenance aspect is coming in, then both the parties are supposed to file an affidavit in this format. Let's see the format made by Supreme Court. So it's very authentic. It begins I, X, daughter of Y, son of Z, aged about 35 years, resident of, do hereby solemnly affirm and declare as under. First of all, you identify yourself and then you declare personal information. Then B is important, details of legal proceedings and maintenance being paid. Court doesn't want a party to claim multiple maintenance in a same dispute. Court says that if you are being paid 10,000 from in a CRPC proceedings in 125, and if the MHA court is also looking into your interim maintenance petition, then they shall see both the orders. And if they see something more is required, then only you should be paid something. So the opportunity for the court to see everything will arise only when everything is disclosed before it. That's why this particular thing has been given a space in this pro forma of affidavit, and all kind of question are being asked. What kind of petitions are pending? Are you getting any maintenance? Are there any arrears pending? All the things are being asked. At page 69, details of children are being asked at para I, and at page 70, some very pertinent questions are there. Whether at para 7, whether assessed to income tax. It's being asked very directly. Are you an income taxpayer or not? If you are an income taxpayer, okay, then bring the income tax receipts. A, 1 year prior to marriage. B, 1 year prior to separation. C, at the time when the application for maintenance is filed. And it moves further. It asks for, at para 9, it asks for furnish copies of bank statement of all accounts for last 3 years. So the scope to lie is being reduced. It's very objective. At page 71, para 2, it says any EMI being paid. So they are trying to assess where do you stand in the life. What are your assets and liability? And at page 72, there are declarations. I declare that I have made a full and accurate disclosure of my income. Two, I undertake to inform court immediately with respect to any material change. C, now they will specify the law. I understand that any statement in this affidavit, apart from being contempt of court, which when we were discussing why affidavits are taken seriously, we discussed enforceability, and that enforceability is written explicitly in this pro forma affidavit, which has to be written in every affidavit which is being filed in a matrimonial dispute. So I will read it for your kind reference. I understand that any false statement in this affidavit, apart from being contempt of court, may also constitute an offence under Section 199, read with Section 191 and 193 of IPC, punishable with imprisonment up to 7 years and fine, and Section 209 IPC, punishable with imprisonment up to 2 years and fine. I have read and understood Section 191, 193, 199, and 209 of IPC. So this is our declaration, and thereafter there is a verification that all the documents given are true. It's my personal knowledge, all those things. And at page 73 is for these agrarian people who are in farming. For them, a simpler version of affidavit is there because their lives are not that complicated as educated people tend to make their lives. So that is there. There is one more enclosure for people of Maharashtra.